An arbitration agreement is actually really common. What is it? It's a contract. It basically says that if you have any type of dispute, that instead of going to court, you have a private judge. The private judge is called an arbitrator. The arbitrator does basically what a judge does on a much more truncated, shortened fashion, a lot quicker, usually cheaper, and the arbitrator makes a binding decision on whatever that dispute is. Arbitration agreements are pretty much the only thing an employer can do apart from perfection to prevent a class action in its tracks. Why is that? Well, that's because an employer and an employee in an otherwise enforceable arbitration agreement can agree that if I have an issue against my employer for wage and hour violations, I'm going to go to private binding arbitration. In other words, I can't represent everybody else, only my individual claims on my behalf. So what that does is it wipes out 4 years of potential liability on behalf of everybody else. It's pretty easy to roll out. It doesn't take a lot of time. It doesn't cost a lot in legal fees. Courts don't like electronic arbitration agreements. Courts have made it increasingly more difficult to authenticate electronic signatures. There's a lot of hoops that you have to walk through to ensure that an employee's electronic signature is properly authenticated, and sometimes it's not worth the trouble than it is to just get a wet signature. You have to have an enforceable arbitration agreement. You need an experienced wage and hour litigation firm because the law changes rapidly. Do you make your arbitration agreements voluntary or mandatory? My position is that every arbitration agreement should be voluntary, and I'll tell you why. Our governor signed a bill that made it illegal and actually a criminal misdemeanor for employers to have mandatory arbitration agreements. Now that got appealed, but that should tell you something about what the state of California thinks about arbitration agreements. Let's remove as many tools or arguments or barriers as possible to allow judges who might be anti-arbitration to strike down your agreement. If you are in the midst of wage and hour litigation and you have not ever rolled out an arbitration agreement, all hope is not lost. If done right and if done strategically, you can still potentially cover employees in the pending class action. We have done that many times. If you do it right, it is a potential strategy to reduce your potential risk in a pending lawsuit.